Now, the third one I want to talk about is dealing with one of my favorites, especially in the Bay Area, probate courts. I've never in my life been in a longer drawn out situation than a probate court. I can tell you right now, as you know, most of the courts have shut down. They're still doing filings. They're still doing things online, but pretty much all the trials are postponed. Everything's postponed until we end the shelter in place. So how do you avoid going to court or having to go to court? What will wind you up in court? And how do you pass your house and some of your assets on to your children without avoiding some problems? Let's look at some scenarios and some situations that we commonly deal with and how you might want to approach this in the future. So let's first talk about a will, because usually when you think about estate planning, when you die, you draft a will, right? A will says, I have X and I want it to go to Y. And so that's usually the way people used to do it. And I like to say a will is merely a letter to the probate judge, and it takes a long time for him or her to respond to that letter, and it can be expensive. So as you start to think about probate, if you've waited a while to do a will or a trust, think about this. The national average of what the fees are going to be on your estate just to get your property to your kids is 2 to 3%. And on top of that, it's going to take a lot of time. And in our county, in Alameda County, could be 2.5 years just to get through that process. We have cases right now that are still going, that have been going for a very, very long time. And that's not any fault of ours. We call the courts and look online all the time. It's just a matter of the system moving you through. And then all of a sudden, maybe they don't like a particular paper you have in the file. Who knows? It's maddening. So in any event, you want to avoid that place if you can. So let's talk about probate and how that works and what are the law, what are the rules. In California, particularly in the Bay Area, any estate that exceeds $150,000 in gross value must be probated. Now, for real estate, so I know some of you own real estate, the value cannot exceed $50,000. I don't know where you could own any property in the Bay Area that's not worth at least $50,000. It doesn't exist. So if you fall into either one of these categories, chances are, if you haven't done a trust, you're going to wind up in that probate I talked about earlier, which you don't want to do. You want to avoid that at really all costs. What are the fees by statute? These aren't fees that we as attorneys make up. These are actually in the law, and you can read them for yourself under the California Probate Code section. I even gave you section 10.810, talks about what are the fees for probate. So on the first 100,000 of your estate, we get paid 4%. On the next 100,000, 3%, the next 800,000, 2%, and then up to the next 9 million, 1%. Now, you may think that's it. So for John and Susan's estate that we were just talking about, let's say that they had $1.8 million in their estate. They own their house and they had a 401k, some investments, some CDs at the bank and so forth. Let's call it 1.8 total. So 4% of 100,000, you can see the numbers here. All in, just the attorney's fees are going to be $31,000. You notice I say we're not done yet, because there's other types of fees. If both the attorney and the executor are involved in this and administering this, the total fees could be double that. They could be $62,000. The estate is responsible for all the costs of the probate. Filing fees could be about $900. I've seen fees be as high as $9,000. So there's a range of fees there that you're going to have to pay just to go through this process. You have to appraise different items. That's going to be roughly 0.5%. You have to file a notice. That could be $150, etc. So if the estate is complicated, and I've seen this many, many times, you would think some estates are simple. They're not. You go into folks' homes and all of a sudden there's all sorts of items all over the place. You have to deal with personal property. There may be items that we don't know anything about, and then we find out about them later. So for all these reasons, it's super important that you make it as easy and as streamlined as possible. And that's what these documents will do for you if you lay them out properly. And it will just save a ton of money and a ton of time. I put this in here because a lot of attorneys deal with what's called extraordinary items. And this is under the section 10.811. Selling a house or defending the estate from a beneficiary who's upset. I'm going to talk a little bit in a minute about how daughter Tiffany may get upset about what her parents do to protect her from her husband. And maybe the son gets upset too. Realize that whenever there's a challenge from any beneficiary anywhere who's upset, that's going to cost the estate money to defend it. So that means that the estate's not only going to pay the attorney's fees, but all the other fees involved in that. So anything the attorney gets involved with fixing up the house, selling the house, that's an extraordinary fee, and that's going to make fees more. So I want to give you an idea here of what that could be in an estate of about $1.8 million, like we were talking about, John and Susan. The attorney fee just to do the first probate's $31,000. Executor gets $31,000. Extraordinary fees another $40,000. Filing fee $96.36 in this case, and you're looking at a total cost of probate of $111,636. All of this could have been most likely avoided by having a simple revocable living trust and will that accomplished 99.9% of what this couple was trying to do. They just didn't do it. Hey everybody, it's David Hollander, the Sandman. Thanks for watching our video, and make sure you subscribe and tell your friends today.